rise. The Court of Appeals Division 1 is now in session.
Good morning. Please be seated. This is the time and date set for our cause number CV240174, Wiltse versus Wiltse. These proceedings are being audio and video recorded as well as live streamed, so I ask counsel please introduce yourself and who you're representing at the beginning of your presentation. Each side will have 20 minutes in which to present their argument. Appellant's counsel is responsible for watching the clock to reserve any portion of that time for rebuttal. Also, we have met this morning, we've discussed this case, we are familiar with the facts, we have read the briefs, and I would like you to take that into account during your argument. At this point, counsel, are you ready?
Yes.
Please proceed.
Good morning, Your Honors. May it please the Court, I am Spencer Schieffer. I represent the appellant, Dean Wiltse. Dean filed a petition with the trial court that raised two causes of action for the very first time. The primary cause of action was for enforcement of Section K of the party's divorce decree entered in 2012. And the second cause of action was an alternative theory for division of unallocated assets in the event that Section K was not enforced.
Is that a separate filing, or is it all contained within the petition to enforce?
It was contained in the same petition.
Okay. Because the only thing I see in the petition to enforce that references 25-318 is the very first statement. It says, pursuant to Family Law Procedure 91 and ARS 25-318. But the entire thing is Section K for the balance.
I could be mistaken, Judge, but I think near the end of the petition there's a reference that in the event that it's not divided, that it be that it's not enforced under Section K, that the unallocated portion be divided under 318.
Okay. Well, let me. I know as indicated by Judge Campbell, we've discussed this at length at conference. Was this a petition to enforce or petition to modify?
A petition to enforce.
Okay. If you had raised it under 318, is that a petition to modify?
I don't believe so, Judge, because there's no modification of the divorce decree.
You want to add something into the divorce decree.
Well, it's establishment of rights that are technically already established under 318.
Okay, well, let's flash over to 25-327. ARS 327 says, the provisions as to property disposition may not be revoked or modified unless the court finds the existence of conditions that justify the reopening of the judgment under the laws of this state. So if you're trying to modify or add to, then isn't that a modification and you have to raise that under Rule 85C?
So technically, I don't think so, Judge. And in my briefing, I cited to the Wright case, 2015 memorandum decision, so it's instructive, persuasive only. In that case, they indicated in part that the claim that the wife brought under 25-318 to establish her share in the unallocated community property was not a modification of the decree, like it would have been when she had filed her Rule 85 motion to reopen the decree. So in that case, they were not viewing it that way. They were viewing it as establishing property rights that were not yet established, not as reopening the decree.
And that was one where the allegation was they were completely unaware of it. It was undisclosed.
Well, in that case, not exactly. So in that case, the husband had allegedly indicated to the wife that the proceeds were his sole and separate property as an inheritance. And so based on that information she relied on, they entered into a decree that did not allocate those assets. She then later learned that was not the case, and so she initially filed a Rule 85 motion based on fraud, which was denied. And then
as untimely?
I don't know if it was untimely or...
It was more than 6 months after the...
That may have been the case. But subsequently to that, she filed the petition to have those unallocated insurance proceeds divided or allocated between them under 25-318. And the court in that case distinguished between the Rule 85 motion, which would have reopened the decree, much like under 327, and changed up the decree as not doing that, as rather as just establishing property rights that were not accounted for in the decree.
Are you saying there's absolutely no statute of limitations for 318?
Under the statute, there is not.
See, I don't, and I have to be honest, I don't read it that way. I read a 318 claim to be a modification of the decree, because and it's based on, you look at the language in 85C3, which talks about fraud and misrepresentation, which is your claim here.
Only in part. So, and not exactly, Judge. So, Section K of the decree in this case does not require fraud.
Okay, but that's a different claim than 318. I'm trying to say, under 318, I just read the statute. It doesn't say we're getting rid of any statute of limitations. It says if it's brought back in, it means it had that character as of the date of the decree. And they could have put something in. There's absolutely no statute of limitations on this, but they didn't. It seems like you have to have a vehicle to get it back in, and if you do, then the character of the property is community property as of the date, rather than when we somehow now brought it back in 5 years later, if it's an enforcement action, or 6 months later. Does that not make sense? You're saying there's your best authority for there is no statute of limitations is right? Is that what you're saying? Do you have any other authority for that?
Well, there's no statute of limitations because there isn't one in the statute. The legislature didn't create a statute of limitations.
But that's why it suggests that you need some other vehicle, whether a modification or an enforcement action or a fraud action. And if you prevail, then that statute simply says the character of the asset was community property as of the date of the decree, even though we didn't prevail on our fraud claim until 4 years later.
I see what you're saying, but I think 318 does not require a fraud claim or something, that type of vehicle. I think what you said earlier is correct in that when the divorce happens, if there's an unallocated asset, 318 treats it as they automatically have an undivided one-half interest in that unallocated property. So their property interest doesn't change and doesn't need to be created.
Why wouldn't you have to make that claim within 6 months if you want to come in and modify it or enforce something within 5 years? It just seems you're saying we can do this 20 years later, and now I found one more account. I can raise another one 25 years later?
I believe the answer is yes under the current statutory framework, because the 6 months you're referring to is under Rule 85 C, or is it C or B now? But as it relates to a fraud claim and establishing property rights that were not divided by a divorce decree under 318 are not predicated solely or necessarily on fraud. It's purely that the decree did not establish it.
Excuse me, but I heard you just say that if they're not allocated in the decree, then they're automatically a community asset. I mean, they're in common, correct?
That's correct.
So you don't need to modify it based on what you just said.
I would agree. It's not a modification.
So it's an enforcement action.
Yes.
All right. And in an enforcement action, at the time that this decree was entered, you had to raise the claim within 5 years. And did you raise the enforcement action within 5 years?
And I apologize, Judge. The 5 years is
an enforcement action is 5 years from the date of the judgment. And if you didn't renew the judgment within 5 years, then it's extinguished and you can't bring an action on the judgment.
As far as renewal of judgments, I believe it's 10 years.
It is now. It was 5 at the time. And the statute specifically says for judgments entered before that date of the change in the statute, it's 5 years. So if it's modifying the judgment, you had to do it within 6 months. And if it's not modifying the judgment, but an enforcement action, as you alleged, you had to do it within 5 years or within a renewal period after the 5 years expired.
Yeah, and let me step back then. So the enforcement that I'm referring to, I guess, is Section K of the decree. So Section K of the decree is what the enforcement action was for, is that the allegations were that there was a community asset that was not disclosed, that was concealed, and therefore under that particular section in the decree, the property rights would be 100% shifted from
Or
wife
if
to
it's not a
husband.
Section K, it's 5 year, it's half of the asset under 318, but it's still an enforcement action. I mean, you filed it as an enforcement action.
That was the initial because of Section K, but and the alternative was to establish property rights under 25-318. I don't know that it's really an enforcement.
How is that consistent with LaPrade, where our court said, no, we don't keep doing these litigation over decree actions on property? The only thing that you can keep litigating is spousal maintenance and child support.
Well, I think there is precedent, like in Cooper v. Cooper, they did allow for the division of community property assets, even when it was known to both parties, but it's not included in the decree. That's one of the key elements, that's whether or not the parties intended or did not intend.
Which decision are you talking about?
It's Cooper v. Cooper. I don't remember the specific statute or the citation. It's in I believe it's in my reply brief.
Can I take a step back too on, this is an enforcement action, but it seems odd to be an enforcement action. What would you enforce? It seems like you need to have liquidated damages, and I think we've had cases that have said, like, if you want to renew a judgment, it has to be for a sum certain. You're contemplating litigating over something to decide how much should go into the community. You don't have a judgment for a specific amount, so you're not really enforcing. It doesn't seem like a good fit for enforcing a judgment, at least from my perspective.
Well, it's not enforcing a judgment as far as a monetary amount that was already awarded. It's enforcing a provision in the decree that says if we find out later that someone was hiding assets.
Is that what enforcing a judgment means then? To say, when you use that term and it says to enforce a judgment, and you have to renew the judgment if you want to enforce it, I look at it, enforcing a judgment is I have a judgment for $500,000. I'm going to go collect somehow. I'm going to do something to get my $500,000. If you don't pay it, I'm going to renew the judgment so I still have it. This seems odd to say that's it seems more logical to call it a fraud case, that someone deliberately defrauded me. But it's different than I have a judgment that I want to renew.
It is different, and I think there's some language that gets muddied up because of the way a family law case plays out. The decree is treated as a judgment, and it can be enforced in multiple ways, more than just a monetary amount where there's some monetary amount that was awarded. The decree can be enforced as a judgment for spousal support that's past due or for
Okay, but there's a sum certain. You're going after that. This, you clearly do not have that. You're saying there's some amount that was hidden, that was as a result of fraud, that's not in there, that you've got to come up with. That seems very different.
Another example, I guess, would be, we enforce parenting time orders that are put into a decree. We also, in many decrees, it will...
But you're enforcing, again, a specific provision that says this number of days or something. That seems very different. Here, you were trying to get an amount that's unknown at this point because you didn't prevail in the fraud action. But if you'd prevailed in the fraud action, then and you got a judgment, then you could record that. If it wasn't satisfied within whatever period of time, you could renew it and you could collect on it you could try to enforce the judgment within 5 years, within 10 years now.
Right. So this is a different means through a specific term in the decree at getting that monetary judgment, akin to a fraud action, but it doesn't require the fraud action.
But you're calling it an enforcement action, even though there isn't a specific clause that we can say we can just take down like a liquidated damages amount. But you're saying this is just a different. What's your best case for saying this is an enforcement action compared to just a fraud claim?
Well, a fraud claim would have compensatory and punitive damages potentially. The only thing that's provided for in the decree here to enforce is the non-disclosure provision. And so under the terms of the decree, the enforcement would be that the asset is divested from the concealing party and awarded 100% to the aggrieved party. So that's the specific term that's being enforced. It's not a monetary amount. It doesn't include liquidated damages like a contract.
Okay, and why would the disclosure part not be subject to issue preclusion? Setting aside claim preclusion, assume we, or at least maybe I agree with claim preclusion that it's not, claim preclusion doesn't apply. Why would issue preclusion not apply if there's been a finding that your client knew or should have known about the asset? Why doesn't that equate with disclosure?
So, and that's really important, Judge, and I want to make this very clear. The prior civil suit and the appellate decision that came from that, I think, conflated some things. There are two assets, technically. There are two accounts at Merrimack. The record indicates that Dean only knew about one account at the time, not the other. There's nothing in the record that indicates
he raised a fraud claim relating to both of them and lost on both, right?
He did, but the fraud claim, issue preclusion doesn't bar this case moving forward, or shouldn't, because the issues, the causes of action for enforcement of Section K, which has nothing to do with fraud, and dividing unallocated assets, those were not actually litigated. They were never raised.
But the issue of disclosure, the issue of whether he knew or should have known about the asset was raised. That was critical to the first decision, right?
And that's an affirmative defense. That's not an issue that has to be raised to prevail on a fraud claim. All he has to prove is that there were fraudulent representations and that he relied on those. The issue of disclosure would have been an affirmative defense that the appellee would have raised. And that only applies to, at best, one of the accounts. And even still, even if that's the case, it's undisputed that neither of the assets, neither of the accounts were divided in the decree, and therefore 25318 should still apply.
Okay, well, let's go back to that. In Reniger, this court said the allocation of omitted property may be accomplished either by separately filed civil action, which is what you attempted to do, or by a motion to reopen the dissolution action, which is a modification. So those are your two options. You can enforce an omitted by filing a civil action to claim you have a right to the community asset, or you can move to reopen. But if you're going to move to reopen, you have to do it under Rule 85, which you are time barred from doing.
I guess, well, for one,
You don't agree with the case, I get that, but
yeah. So for one, I mean, granted, it's instructive only, it's not an opinion, but the Wright case didn't do it that way, right?
No.
The Wright case allowed.
This is an opinion.
What's that?
Reniger is an opinion.
Right, I get that. So I'm saying that is not how it got applied in the Wright case. And then as far as having to file a civil suit, I mean, we have cases all the time that say it's all one court, whether it's family court, civil court, it's all one court.
Well, but that's not the, you can file a civil action to try to get it declared as half yours. Or, in your case, you file it as a fraud claim. Or you can file to reopen the decree, but you have to do that within 6 months.
Well, I don't think the civil suit is required in 6 months. The reopening of the decree is. But that's not what we're trying to do. We're not trying to reopen the decree.
You lost on the civil suit.
Yes.
And now you're trying to either reopen or enforce. And it seems to me you're having a hard time because there's a 6-month limit on reopening and there's a 5-year on enforcement.
I guess, to me, the 5 years should not apply because the 5 years is about monetary judgments, right? Like the 5 years doesn't apply for enforcing a parenting time schedule. It doesn't apply to support judgments. There's no monetary judgment that's already in place that has to be renewed. This is enforcement of a provision that would create or change a property right based on the terms of the decree. So I don't think that the 5-year or 10-year renewal provision would apply to this portion of the decree because it's not in itself a monetary judgment.
Did you list a monetary amount in your petition to enforce? Didn't you write down to the penny, if I remember correctly?
We did, but that's not a judgment yet. We are seeking a judgment for that amount, but it's not a judgment to be renewed. The decree provision just is in effect. And I don't think that the provisions of the decree that are not monetary judgments have to be renewed under a 5 or 10-year under Title 12.
So under your interpretation, it seems like somebody can sit back, be fully aware that there's stuff out there, and let time just go on and on and on and on and on, and there's no end point to it. Is that what you're arguing?
Well, that's why we have the affirmative defense of latches, and that was not argued in this case at the trial level. And so, in a sense, absent a statute of limitations, and in the terms of this decree, there is no limitation that was placed on it. It was either, in part because if an asset is concealed, when would they know about it? So we did have, Dean did have knowledge
That's a
of.
fraud case if an asset is concealed, and you pursue it that way. But if you don't win on that, then it wasn't a fraud case, and then we have a decree, and we've got to have finality at some point. If you want to modify that, you need to do it within 6 months. And if you just want to enforce something that you already have, then you get now 10 years. But sorry to just ramble here, but could I backtrack on, let's say it's spousal maintenance or something. Can you wait after it becomes due? Can you wait 15 years to come in and make a claim for spousal maintenance?
Well, there is a specific statute of limitations for spousal maintenance. And so, but unlike 25318D, there is no statute of limitations. It just establishes the property right for any property.
I thought spousal maintenance was a petition to enforce spousal maintenance. That's what it is. You get a judgment, and then you have to then enforce it within that period of time.
Because the statute specifically states that. And with each month that passes, the spousal maintenance payment becomes a judgment in and of itself with each month.
All right, your time has run, counsel. Thank you.
Thank you.
Good morning, Your Honors. Patricia Primo with Nearhead Law. With me is my associate, Sucleen Ball, and we're here on behalf of the appellee, Barbara Wiltse. We draw the court's attention to the unopposed motion that had been filed in the civil fraud case, where Barbara Wiltse requested the court to transfer the case over to family court because of her concern that if she wins in the civil court, she might someday find herself back in family court. It was an unopposed motion. Prior counsel for Mr. Wiltse had said, well, in our opinion, it can be civil or family. Again, we're all one superior court. We don't take a position one way or the other, but the trial court said, we are one court, Renegar. We're one court. They have a choice to file it as a civil action or in family court. Here Barbara Wiltse is. This is her third time on appeal in connection with her divorce proceeding. There was an appeal from a contempt order against Mr. Wiltse in the family court matter, where it was appealed and the Court of Appeals said, hey, you sold stock violating a court order, and the trial court didn't give Barbara enough damages. So that was appeal number one. We have the fraud claim. We cite all of the testimony of Dean Wiltse knowing about the $241,000, and again, in that civil lawsuit, down to the penny. She concealed, she sequestered, she omitted, use any phrase you want, $241,000, she took it, lost on summary judgment. Trial court in the civil case says, frankly, there is no reason for this case other than to harass Barbara Wiltse. That was up on appeal. I apologize, Your Honor.
The whole
Go
thing
ahead.
was knew or should have known about these funds.
Right.
Okay, that's really the only thing that's, in my mind, relevant at this point. Okay, you have a holding dismissing because Mr. Wiltse knew or should have known.
Knew or should have known,
Yeah.
and it was barred by the statute of limitations.
Okay, and does the fact that if it turned on should have known, does that prevent a claim under the decree that said an undisclosed? He just should have known, but the decree says an undisclosed asset is going to be treated this way. And if we reject your argument that, or the trial court's conclusion that claim preclusion applies, why would that provision not provide a vehicle for relief?
Your Honor, as far as the undisclosed assets, there was an express finding regarding one of the assets. Again, it's the app for TRO saying 123,000.
Right, so assuming we.
So that one.
That one's off the table.
That one's off the table.
Okay, but how about the rest?
The other undisputed evidence is that the second account had his name on it. He was a named party on that account, and that's what was established through through the initial lawsuit where Dean Wiltse was simply called in to testify against Barbara. He had no dog in the fight, but he absolutely testified and admitted that he was named on that account. You can't conceal an account that you're named on. I mean, it is common sense. So he admits in a court pleading, you can take the one account.
Well, it seems like you might have an argument. I understand that it might be an unpersuasive argument, but if she has essential control of this, you're saying just because his name is on it, he necessarily is aware of what's in the account?
I think it would be hard to argue otherwise that if I have an account, I can't accuse my husband of concealing it from me when it's my account.
But if he's not aware that something else has gone into the account, he had no reason to be aware of that. My question is,
Yes.
Is it a factual question that needs to be resolved as opposed to something that can be addressed simply in a motion to dismiss? His name is on the account, ergo he knows everything that's in that account and nothing to see here.
That is our position, that there is nothing to see here because his name is on the account. There is no factual dispute. If you sign a contract but you didn't read it, the law is very clear. You're bound to know what it is. It's not an excuse that I didn't read it, etc. So if your name is on the bank account and you say, oops, I didn't realize how much money was in my bank account, the same analogy in my mind would apply, that signing a contract without reading it, having a bank account where you don't allocate it within the divorce decree, you know about it. It does, and more importantly, though, Your Honors, it goes back to the issue of the statute of limitations, which was the basis, and the statute of limitations goes hand in hand with, because he knew about all of the money. Not just part of the money, he knew about all of the money. And that's what came out.
Well, but the basis is should have known. And that's my question. I understand it. It's probably not a very persuasive argument, even if he got a new trial or got to go to trial on the issue. But should have known that necessarily establishes that it was disclosed. And that's the only holding from the previous case, is if the holding is he should have known, therefore you lose on statute of limitations grounds on fraud. But does that, maybe he didn't know, but he should have known. Does that satisfy the disclosure?
It still satisfies the disclosure, Honor, because the should have known is based, again, on if your name's on the account, if you signed the contract. So the court didn't need to go any further than that. And again, we've got 3 separate lawsuits here. We've got the very first civil lawsuit where he says, yes, I knew about the first account, I don't care about it. The second account, yes, I'm a signer on it. That's to me, that's not even a should have known, that's a known. But if the court were to adopt it as a should have known, that still doesn't change the fact that under Renegar, that he had the opportunity to choose a civil fraud case or to enforce or to modify the divorce decree.
I seem to recall cases where the parties knew about an asset, but it didn't work its way into the decree. And the case I'm thinking about that I can't remember the name of, it seemed like it was at least a couple years later. And the court said, no, this one should be divided. It seems to me you would have some kind of problem with a statute of limitation.
I know that there are some cases where, and again, I'm drawing a blank and on the name of the case, where there was, I'm gonna remember it, the Wright case. There were 3 Wright cases, and in fact, Judge McMurdy, I think, had the pleasure of being on the 3rd Wright case.
It's always a delight.
Oh, my gosh. So we're in the 3-timers club here as well. But the idea is that there's a factual dispute sometimes as to whether something was intentionally left out of a decree, and sometimes it gets remanded as to whether summary judgment was appropriate or not. That's not what anybody has alleged in this case. What we have alleged is that if you file a civil lawsuit for fraud, concealment, sequestering, add any other, adjective or adverb that you want for it, and you lose. And you don't just lose, you lose and you get sanctioned. And you go up on appeal and you lose and you get sanctioned. And then we are literally talking a divorce that was filed in 2011, a decree that was signed in 2012.
But you're talking claim, you still have to break it down. Is it
Yes.
claim preclusion? And Arizona has a different test, maybe one that I don't necessarily agree with, but if it's not, if there's no claim preclusion and you can bring it somewhere else, it seems like you have to have a different basis for rejecting it, whether it's a statute of limitations or saying it doesn't fit somewhere. But if you lose on, and the court relied on claim preclusion in this case, and assume we disagree on claim preclusion, how do we affirm?
One, the court, as you know, can affirm for any reason. If the trial court got it the right result for the wrong reason, this court is able to fix that, for example, on a statute of limitations issue. The second issue is claim preclusion. If the court is unpersuaded by claim preclusion, you've got issue preclusion, which goes back to whether the exact same claim being brought today could have been brought in the other case.
You're talking claim preclusion. The claim could have been brought. That's claim preclusion. What about issue preclusion?
I apologize. I reversed that. As far as issue preclusion, the issue is the knowledge.
But it should have known.
But it should have known.
So, and that's different. I mean, it seems like should have known is different than actual knowledge. And I agree. At least half of this is there's clear knowledge. I don't know how do you get around that, but there seems to be another 100,000 or something that is maybe should have known, and that seems different. But the way for us to affirm if we're saying the ruling was just should have known and claim preclusion is off the table, what's our basis for affirming?
Your basis for affirming is, one, as you said, the statute of limitations, and two...
Which statute of limitations?
Whether it's under Rule 85 with the 6 months or the renewal aspect of a judgment after 5 years. Again, the court looks for finality. There was a finality in the 2020 or the 2019 case. That's how long ago that civil lawsuit was filed, in 2019. There was finality that says you don't get the 241. You don't get to reopen in family court and say, okay, but now I want the same exact 241 down to the penny that the trial court and the Court of Appeals already said I'm not entitled to get it. And with Reniger, that he could have brought it. And we asked, and I do stress, we asked for the civil fraud case to go over to family court because of our concern that we'd be here again.
At the time of the filing, though, was it already too late to go to the family court as it relates to the family judgment? Because the 6 months has run under Rule 85, and the 5 years has run under a petition to enforce the judgment. So isn't his only claim at that moment the fraud claim in a civil action?
If the court adopts that reasoning, you are correct. I will be the first to admit, and I probably shouldn't do this, that I am not a family lawyer. I represented Barbara Wiltse in the civil fraud claim, and my goal was to get it so that the family lawyer who handled all the family stuff, who knows about the, 12-year history of the family divorce case would then step in. And when that didn't happen, that's why we said, okay, the family court could have heard it presumably as a fraud claim, or perhaps even that's why Judge Bailey wanted to keep it. And just a little bit of interesting history here. Judge Bailey was the family court judge in this matter, and then she became the civil court judge in the fraud case. So she also knew this case really well, and there was a little bit at the oral argument of that. I know this case, civil and family, we're all the same. They're busy over there. I can handle this case because it's all one superior court. And I'm paraphrasing, of course, I don't have a transcript, but that's where the conversation stopped, which was, as long as this court can resolve the issues, as long as we're not going to get dragged back into family court. I mean, again, it was an unopposed motion to put it over into family court so that a final judgment could be entered. That's what we thought we got in the 2019 lawsuit.
Yeah, I'm just not sure it matters which court addressed it. They would presumably still be raising a new argument saying there was an undisclosed asset, and if it's not barred by claim preclusion, let's say this had been addressed, a fraud claim in family court. Under counsel's theory now, he could still have come back and said there was an undisclosed asset, and the only ruling we've had was should have known. That doesn't mean I knew about it. It wasn't disclosed. So the whole, whether it was civil or family court, doesn't seem to matter, at least from my perspective. But that goes to but in your response, you haven't really alleged that it's barred by the statute of limitations, by Rule 85, or by the statute of limitation, by the 5-year period under the enforcement.
We have not alleged that, and candidly, this morning's oral argument was the first time that I think anybody has raised any of those issues. We focused primarily on the Reniger case, that if you could have brought the claim, then even if you didn't, you could have, therefore you don't get a second bite at the apple. And if the court disagrees with that reasoning, the court has the authority, the wisdom of a 3-judge panel to decide that maybe everyone got it, the right reason for the wrong result, and it's more of a statute of limitations issue. But either way, the inherent injustice for Barbara Wiltse of coming into the court 12 years after a divorce decree has been entered to say, oh, wait a minute, but what about that account? There has, whether it's a statute of limitations, whether it's enforcement of a judgment that bars subsequent litigation, there needs to be finality.
It's just that these are dismissed on a motion to dismiss, and the basis for a motion to dismiss was claim preclusion. And if that's wrong, we don't really look at the overall injustice of what's happening. We have to go by what the parties argued. If that had been the only claim preclusion, and the court rules this claim is precluded, we have to send a case back, even though we might not think it's a fair result.
Do we really have to send it back, or can we affirm it on any basis that is supported by the record?
You can affirm it on any basis, and we raised both, again, claim preclusion and issue preclusion. We raised both of those issues. We cited Reniger, the trial court cited Reniger, but absolutely this court does not need to remand for a finding as to whether 12 years later Dean Wiltse knew about a bank account with his own name on it. I think it stretches credibility to say that his actual testimony in the very first lawsuit, where he admits that he has the account, it's under his name, that is the analogy to if you sign a contract, you're bound by it. If you have your own bank account and you're going to allege that it was not disclosed to you when it's your own, The court doesn't have to deal with should have. The court can take judicial notice and say, he knew because he was on the account.
There's no circumstances under which he could have an explanation for that. Again, we're hearing motion to dismiss.
I do agree that it's a motion to dismiss, and the motion to dismiss was based solely on the findings from the 2019 civil court case, which relied on testimony he provided in a 2017 civil court
But
case.
testimony it's clear as to at least half of it.
It's clear as to at least half of it. Our position is that it's clear as to all of it. Any further questions?
Thank you, counsel.
Thank you.
Well, at this point, we thank you for your arguments here today and your briefing. We will take this matter under advisement and issue a written ruling in due course. We are adjourned.